welcome everybody. It's wonderful to be here for this event that's co-hosted by University of Sydney Law School and the ARC Centre for Excellence for Automated Decision Making and Society. It's a great privilege to be able to introduce our speaker today, Professor Matthew Sagg, who's Professor of Law in Artificial Intelligence and Machine Learning and Data Science at Emory University Law School. Professor Sagg is an expert on copyright and IP, and he's worked extensively in the area of fair use, where he's written also about the context of artificial intelligence. It's a particular pleasure to welcome him here, as he is born and educated in Australia at ANU. He was a clerk for Justice Paul Finn of the Federal Court and has practiced in London and Silicon Valley. So prior to joining Emory Law School, he taught at DePaul and Loyola Chicago. This year he gave testimony to the US Senate Committee on the Judiciary Subcommittee on AI and IP, so I can't think of anyone who's better placed to talk about this complicated, tricky, but very important issue of copyright and artificial intelligence. To join us.
Thanks, Daniela, for that very kind introduction. Thanks to Sydney Uni and the ADM Centre for sponsoring this event. And thank you all for coming. It's really nice to see you. So I'm going to talk to you today about copyright and generative AI, and in particular about why we should be thinking about copyright safety for generative AI. I'm going to start with a brief introduction to generative AI. I'm going to assume that none of you have been living in a cave for the past few years, and so you're familiar with ChatGPT, Midjourney, Stable Diffusion, DALL-E 2, things like that. But it's worth thinking about how generative AI is perhaps a little bit different to earlier generations of machine learning technology. Generative AI is trained on books, movies, music, text in all manner of forms, photographs, digital art, almost anything that you can think of. But that actually doesn't really differentiate it from what I think of as old school machine learning. Sorry, I realized my slides were a little behind. My slides are as jet lagged as I am. What's interesting about generative AI is that it doesn't just classify these objects or derive metadata based from these objects. Generative AI produces new digital artifacts. That's why we call it generative. It's producing new text, new photos, new music, etc. And it's doing this at a quality that passes the Turing test. It's doing this such that in many cases we can't tell the difference. Now, that seems like a bold claim, but I'll point out that in September 2022, Jason Allen won a division of the Colorado State Art Fair with a picture that he created using Midjourney. He didn't disclose this. People were quite mad. Generative AI also is capable of working at a speed and scale that is beyond human capacity. Oh, there we go. My dot points are going to be completely out of sync, apparently. Generative AI is a transformative technology, and I mean that in both a positive and a negative sense. I don't know where I should be pointing this thing. There are many risks and rewards from generative AI. Generative AI may produce an unhealthy dependence on technology. It may lead to cultural homogenization. If you believe some people, generative AI is one step along the path to superintelligence that will one day destroy us all. On the plus side, generative AI is clearly going to make a lot of people a lot more productive. It's going to enable new creativity. It's going to enable better and different forms of education and training. It is going to accelerate scientific research, and it is already now making whole new forms of scientific research possible. And if you're thinking of generative AI as producing fun little images on Midjourney, yes, that's true, and that's very impressive. But some of the most profound implications of generative AI are going to be sifting through scientific texts and generating new hypotheses, looking for overlooked relationships that are already inherent in the underlying literature. And these things may provide the next cure for the next pandemic or similar things. So why are we here talking about copyright then? Right? The risks and rewards of generative AI seem to raise a lot of big policy questions that copyright is particularly poorly calibrated to address. But the copyright discussion is inevitable because there is a lot of copying underpinning generative AI, and copyright law, as many of you know, has a lot to say about copying. Stable Diffusion was trained on about 2 billion images. GPT-4 was trained on, we think, probably 100 million copyrighted works drawn from maybe 15 million websites. All of that copying requires some kind of justification. Otherwise, under US and Australian law, it is infringing. However, it's really important to understand the actually quite limited role that copying plays in generative AI. So I have kind of a complicated little diagram here that breaks down the process of producing and deploying a generative AI into 4 stages. I'm just going to step back so I can read my own slides. The first thing you do in developing some new generative AI model is you figure out what training data do you want. You get access to the training data. Accessing the training data is not actually necessarily a copyright relevant activity, right? It could be that you are the Stanford Library and you want to train a generative AI model on the books in your library. Well, just collecting a whole bunch of books that you already own is obviously not a copyright issue. Where the big copyright issue comes is that in order to use these works as training data, you need them in a digital form, and practically speaking, you want to host them on your own servers. So it's technically possible that you could train a generative AI model without a locally stored copy. You could just send an agent to the internet and have it abstract from an artifact on the internet, report back some information, and then train from that. No one does this, right? It's basically technically not feasible. It would take hundreds of years to train GPT-4 in this kind of way. And you wouldn't be able to do all the important things of deduplicating the training data, taking out all the references to Adolf Hitler, et cetera. For all of that good work, you really need a locally stored copy. And so I don't know this for a fact, but I would be shocked if the training data that OpenAI uses isn't sitting on a server somewhere in Mountain View, right? That is copying, right? And it's not a temporary or fleeting copy. That is a semi-permanent copy that is clearly a copy under the Copyright Act. What may surprise some of you is that that is usually the first and last actual copying that goes on in generative AI. So the next step is the sort of analytical process of training a model or deriving metadata. And as I'm going to explain in more detail in a minute, that's usually not copying. And then the model that results is usually not a copy of the training data. And then the things that the model produces are also not copies of the training data. there are 3 reasons for this, and I'm going to walk through these in a little bit more detail. Starting with point number 1. The process of training something like a large language model is preceded by a ton of copying, but the training process itself is not copying. The way a model like Llama or GPT-4 works is that it is trained to predict the next word in a series of words. It's actually trained to predict the next token in a series of tokens, but the difference between words and tokens is not super important for us today. So, take a sentence like that begins, "The girl with the dark." What's the next word? Wow. It's a lot of consensus around hair. Someone said skin, someone said eyes. If I could just query you, why did you say hair? Where did you read that? Yeah, you heard it once? All from the same source? Yeah, so if you completed this sentence with hair, then, congratulations, you're in the vast majority of people I've ever asked this question to. It's interesting to think about why you did it, right? It's not because you read it once and your brain made a copy of that sentence and then you were like, oh, that's the next word. It's actually because in your many years on this planet, you have learned a lot of things about the English language. You've learned about grammar and syntax. You've also learned a whole bunch of weird cultural assumptions about the kind of things we in our Western society choose to observe about girls rather than men, people, humans, right? And so all of that knowledge is based on not just reading something once and copying it. It's based on developing your own internal model of what is likely, what makes sense. To that extent, GPT-4 is the same. Now, the analogy between an AI model and the human brain can be well overdone, but it also partly holds. So there's a reason why you thought hair was likely and propeller and semicolon and harmonica were unlikely. When you train a model like GPT-4, you start out with, billions of parameters, all set with random weights. You then ask the model to guess what the next word is. When it makes a good guess that is closer to the actual ground truth that you're training on, the things that led it to that guess are upvoted, basically, and reinforced in the next round of training. When it makes a bad guess, like propeller or semicolon, the things that led it to that guess are effectively downvoted, and in the next run of the model gets a little bit smarter. Now that seems like an incredibly haphazard way to develop a large language model, but with enough data and with enough rounds of training, it ends up to be quite remarkable. But my point is that the model is not a copy of any individual text that it was exposed to. The model has, in some very real way, learnt from all of the texts. My second point, and I'm going to use a visual illustration for this one, is that when these models learn, they learn at a fairly abstract and usually uncopyrightable level. So on the left-hand side here, you will see a bunch of images labeled coffee cup that are in the Stable Diffusion training data. On the right-hand side, you will see my image of a coffee cup that is also a portal to another dimension. What's interesting about this comparison is you can see that the Stable Diffusion model has learned some abstract associations with coffee cup. Apparently coffee cups are white, they're ceramic, they have a single small handle, they have a liquid in them that is sort of brown and black. But you'll see that compared to the training data, gone are the sunsets, sunrises, bodies of water, women with smooth skin, men with facial hair, cakes, weird alien creatures, et cetera, et cetera. The model, as it learns, is abstracting away, looking for the consistent features in order to build its probability model that is essentially guessing that, well, if the word is coffee cup, the image should look something like this. That is really significant for copyright law, right? The model is not a copy of the training data, and the things the model is learning from the training data are abstract and uncopyrightable. More than that even, when you ask the model to produce something, when you prompt it, the model is combining these latent concepts and usually generating something quite novel. So when I asked Midjourney to produce a teddy bear in rich, opulent clothing with a hypnotic stare reading a newspaper, undoubtedly, that picture is influenced by a latent concept of a teddy bear learned from all of the images tagged teddy bear, and a latent concept of reading, and a latent concept of newspaper, et cetera, et cetera. But the image that results is pretty wildly different to all of those things that are in the training data. It is, in fact, a novel point in the sort of latent space that is sort of implied as sort of sitting between all of the sort of abstract features in the latent space. The fun thing about this picture is we're not even sure if the bear actually has a hypnotic stare. The bear is wearing sunglasses. The stare is left to our imagination. So there are some complicating considerations. Sometimes the things I've told you are not actually true. I feel like that glass of water is in peril. Sometimes these models are so large that in specific conditions, they will actually memorize the training data. This image is from the Getty Images complaint against Stability AI. And if you know your Premier League football, you'll realize that that's Christian Eriksen and some guy from Liverpool, his name's not worth mentioning, Tottenham fan. And then on the left-hand side of that image, you have their strange, mutated golem doppelgangers. I'm not sure that this particular example really passes the threshold of substantial similarity, but it's worth a go. It's not completely remote from something that could be deemed infringing. How does this happen? In this particular case, it happens because the text description that accompanies the original photo is incredibly long and specific. And so when you feed that long and specific text description into Stable Diffusion, the model has basically just learnt one thing associated with it, right? So that's one way you can get memorization. The more common way is that there are just too many duplicates of the same thing in the training data, right? This is what the computer science literature has figured out over the past sort of 18, 24 months, that in these type of conditions, you actually do get memorization. It's incredibly rare, but it does and can happen. The thing that the computer science literature has overlooked is what I think of as the Snoopy problem. Right? The Snoopy problem is that when we protect things at a fairly high level of abstraction, the way we do with copyrightable characters, then models are much more likely to copy them, because so much less is required to copy. I'm going to hazard a guess that you all know what Snoopy looks like. Well, Midjourney and Stable Diffusion, they know as well. They have learnt Snoopy in the same way they have learnt banana and aeroplane, right? And so when we protect things at a more abstract level, infringement by text-to-image models is more likely. The third thing I think it's interesting to point out is that if and when these models are used to infringe, we can attribute that infringement to the model, i.e. to the people who created or ran the model, or we can attribute it to the user. And whether we should attribute it to one, the other, or both is going to depend on the circumstances. And so on the screen, you'll see my attempt to infringe the copyright in Ian McEwan's novel, Saturday. I started by asking ChatGPT for a summary. I then told it to outline the sequel. I then said, outline the first chapter, and then, begin to write the first chapter. And I never even made it through Saturday. But I showed this to my wife, who's a fan of Ian McEwan, and she's like, yeah, that's actually pretty good. And so you can imagine you could write your own sort of third-rate Ian McEwan infringing sequel using ChatGPT. And quite frankly, there's a lot of sort of similar stuff like that available on Amazon now. And the question is, well, who's responsible for that? Is OpenAI responsible because there is a lot of knowledge about Ian McEwan embedded in the novel? Or is it the user who's sort of deliberately and systematically pieced together something that is infringing? It is true that in the hands of a dedicated user, these things can be tools of copyright infringement, but that statement also applies to the typewriter, and so I'm not sure how far it takes us. Okay, let me say a few brief words about the current litigation landscape in the US. And I'm happy to talk more about this in Q&A. I'm going to go at a fairly high level. We have a ton of lawsuits. Most of them are class action lawsuits. Many of them are filed by the same law firm. Many of them are, in fact, carbon copies. So when you hear, oh, Sarah Silverman filed a lawsuit, and I'm blanking on the name, the person who wrote The Cabin at the End of the World, they filed a lawsuit, right? It's the same lawsuit. It's the same firm. It's the exact same complaint. It even defines the same class. So don't be too impressed by the multiplicity of lawsuits. The one that stands out is Getty Images' suit against Stable Diffusion, right? That's just on behalf of Getty Images, and I think that claim is going to be one to watch. There are, putting aside the defamation lawsuits, which is kind of a whole different subject, there are 11 lawsuits that we should all be watching at the moment. They're almost all class actions. They're almost all filed in California. The Authors Guild class action is filed in New York. Getty filed its lawsuit in Delaware. The reason we have so many class actions filed is because under American class action law, if you want to represent the class, then it helps to have filed one of the early suits. What should we make of these lawsuits? Oops. They're all at a very early stage. Complaints have been filed. The complaints have not been answered. We don't know what defenses will be raised in these cases. Class certification, on my slide I've said is not guaranteed. I think I will actually go one further and say is really unlikely for a lot of these because the classes are too diverse and have interests that are too conflicting and diverse. And these classes inevitably also cover a range of copyrighted, sort of registered and unregistered works. There are lots of speculative theories of liability in these complaints. Some of them are kind of silly and they will be preempted by American federal copyright law. The privacy complaints, I'm not a privacy expert, but they didn't strike me as particularly credible based on the technology. But discovery will yield some more insights there. There are a few serious non-copyright causes of action, particularly trademark infringement and trademark dilution. I mean, Getty Images makes a pretty solid point in its complaint that Stable Diffusion is producing images that aren't Getty images that have the Getty watermark attached. That seems like a problem under trademark law, and to the extent those images are poor quality, that also sounds like a claim for dilution. There's also a right of publicity claim in that the text-to-image models are generating images that are associated with the names of artists, and those artists had nothing to do with those images. So that's also potentially problematic. But the main action is in copyright. There are several different copyright theories, and there are a couple of sort of sneaky, almost copyright theories that are pled to try and get around the fair use doctrine. They won't work, right? The major copyright theories are that when works were copied for the purposes of training, and those works were subject to an open source license or a Creative Commons license, that license has been breached because of the lack of attribution. That's a good theory, except that it assumes that a derivative work has been created. Those licenses only bite when you create a derivative work based on the copyrighted work. So if there's no derivative work, as there mostly isn't, then there's no infringement. One of the other complaints is about copyright management information. The theory is our images, our texts had copyright management information, and the US code makes it an offense to remove or alter that copyright management information. And there's no fair use exemption to that provision. That's true. Is also entirely misleading, because when you look at those provisions, well, one, you need to do it knowingly, but two, you need to do it intending or knowing that it will facilitate some underlying copyright infringement. So if the fair use defense holds, then there is no underlying copyright infringement, and the CMI complaint is just a distraction. And if the fair use defense doesn't hold, then why are we talking about CMI when we can just talk about a violation of the reproduction right? The really straightforward claim is that you copied all these works and you stuck them on a server without our permission, right? And there the issue is fair use, and I'm going to turn to that in just a couple of minutes. The less straightforward variation of that claim is that these models are entirely dependent on the data. Therefore, everything they produce, and in fact the models themselves, are derivative works based on the training data. That sounds plausible, unless you know anything about US copyright law, in which case it sounds ridiculous, right? It sounds ridiculous because to be a derivative work, you can't just have a but-for causal relationship with some copyrighted work. A derivative work is something that actually embodies a substantial amount of original expression from the original copyrighted work. So a poem inspired by a painting is not a derivative work, right? Even though it would not exist but for the painting. So the derivative work argument sounds all right in theory, but actually doesn't hold up. So what we're left with is the substantial question is, well, is all this copying justified by fair use? All right. I'm going to give you like a brief, very brief overview of why this is fair use under US law most of the time. Right? And I really want to emphasize the most of the time because I think there are some specific arguments you can make in specific cases. All right, so the fair use doctrine. The fair use doctrine has actually been around in one form or another pretty much as long as statutory copyright has existed. It starts off as a bunch of English cases in the 1700s about fair abridgment. It sort of develops and mutates, becomes fair dealing and fair use, and then in 1976, fair use is encoded into the US Copyright Act. The way the US Act works is there are 4 statutory factors: the nature of the work, the purpose and character of the use, the amount and substantiality of the portion used, and then finally, the effect on the market for the work or the value of the work. The thing you need to understand about the statutory factors is it's not a checklist, right? You don't just score down the factors and say, well, I've got 3 out of 4, it's fair use, right? Fair use does not work that way. It can't work that way because the factors are all interrelated. The second thing you need to understand about the way fair use works in the US is that you can't just read the statute, you need to read the case law. The case law says a lot about how the fair use doctrine should be interpreted. When Congress encoded Section 107, it explicitly said, we want the common law development of fair use to continue. The biggest piece of case law that you need to know about in terms of US fair use is, of course, Campbell versus Acuff-Rose, that introduces the concept of transformative use. Now let me talk to you about what I call the non-expressive use cases. We have a series of cases dating back to the 1990s that are not about your traditional transformative use, where you take part of someone's expression, you use it in a completely different way, often commenting back on their original expression, and that use is sufficiently different that we hold it harmless and we're going to call it fair use. In these non-expressive use cases, we have entire works being copied, but used in a way that is completely, almost unrelated to their original expression. And so here are some examples. Software reverse engineering. You decompile software in order to dig out the uncopyrightable elements, APIs, interface codes, etc. Courts have consistently held that that's fair use. Turnitin.com. Do you guys have that here? It's automated plagiarism detection system. Well, that was challenged by a couple of Virginia high school students, and the court said, no, that's fair use. Yeah, it will depress the market for cheating on student term papers, but if all you get at the end of the day is a report that says, oh yeah, this is likely plagiarism or not, that is, in the case they say it's highly transformative, I think it's more useful to see it as non-expressive, right? Expressive works go into the system, but uncopyrightable information comes out of the system. Copying HTML web pages. Every search engine relies on billions of copies of HTML web pages, right? The robots go out, they find the web pages, they copy them, they then use that information to produce a search engine index. Internet search would not work without this copying. And yet, the data that comes out is just metadata about the HTML pages. It's not the content or the substance of those pages. And that brings us to more recent cases. So another non-expressive use is copying printed library books in order to allow English professors to do large-end statistical analysis of not just a few individual books, but entire collections of books. And then finally, we have copying the same library books in order to produce a search engine. courts in, oops. It's a shame that my initial dot points went away. This was meant to show you the cases associated with all of those points. Courts in all of those cases found the use transformative, even though most of the examples I gave you were commercial. And they did so primarily because these are non-expressive uses. Oops. If you're really in the weeds of US copyright law, you might be thinking, oh, well, what about the TVI's case? What about the Meltwater case? There are cases that are superficially similar that go the other way, but when you actually look at these cases, the defendants in those cases lost because their use was not non-expressive. The defendants in these cases lost because rather than just doing statistical analysis about the copyrighted works, they were actually displaying very large chunks of these works. In the TVI's case, the average Fox News bulletin is 90 seconds, and TVI's was hosting up to 10-minute previews. Well, a 10-minute preview of a 90-second news story is pretty substantial. It's clearly an expressive rather than non-expressive use. The other telling thing about these cases is that the non-expressive uses were not even challenged by the plaintiffs. The plaintiffs have read Hathitrust, Google Books, and didn't even run that theory. They just ran these snippets seem awfully large and not particularly fair, and the courts found that convincing. Why does this make sense? I think that copyright law is not about the prohibition of the mechanical act of copying for its own sake. I think that the purpose of copyright law is to protect the author's interest in communicating their original expression to the public. If that's right, you're certainly entitled to have a different view of copyright law, but if that's right, then that makes fair use make sense. Fair use is not opposed to copyright law. It's not working against copyright law. Fair use is doing the same thing as the rest of copyright law by allowing uses that don't interfere with the author's interest in communicating their original expression to the public, by saying, yeah, those uses are harmless. Those uses can continue. Those of you who are taking copyright law now are probably familiar with the Supreme Court's decision in Andy Warhol. And the question is, oh, well, does Andy Warhol change this? Yes, Andy Warhol changes this by making it even clearer that the benchmark for fair use should be expressive substitution. Andy Warhol, the Supreme Court decided that taking a photo of Prince and cropping it, overlaying some colors, fiddling with the contrast, etc., admittedly using screen printing, not Photoshop, that even though that added a layer of new aesthetic, you could still see the old aesthetic. You could still see the old work. Some of us see the old work very clearly, and that's not enough for fair use. What I think is really great about the Andy Warhol decision is it basically supplies the limiting principle that was always missing from Campbell versus Acuff-Rose and transformative use. You can't just say that any transformation, no matter how small, no matter how slight or trivial, makes something fair use, right? The court in AWF says, no, transformativeness is a question of degree. It says this 3 different times. And then when you really drill down, you'll see that what they say is, the question is this use going to substitute for the author's original expression? The thing about non-expressive uses is they don't do that, by definition. All right, I feel like time is running a little long, so I'm going to skip past this, which we might do in Q&A, and just close with some thoughts about copyright safety, which is, after all, the title of this talk. So why, given that I'm advocating a fairly robust case for the fair use of generative AI in general, why do I think copyright safety is important? Well, one, pragmatically, as persuasive as my arguments are, the Supreme Court has never explicitly approved them. The Supreme Court has never addressed a non-expressive use copyright case, so I guess we don't know how they would handle it. It would be shocking to me if they wanted to overrule HathiTrust or Google Books, but they could. But more importantly, we actually know that there are some predictable situations where these models will copy, where they will produce infringing output. And also, more broadly, copyright interests are not the only interests at stake. And so there is a lot that the companies pursuing this technology can do to make it fairer, to make it more responsible, and I think that they should do those things. In my paper, I have 10 different recommendations. Here, I think I just want to summarize at a high level what I think are the most important ones. Most obviously, deduplicate the training data. It turns out that that can be a lot harder than you might think. But certainly, that's the sort of the first stage. I think when models are going to be open sourced, companies need to do a lot more work up front to think about how they structure the way the model learns. There's no reason that Stable Diffusion should have been released being able to draw a picture of particular actors or the styles of particular living artists, not for copyright reasons, but for just general human decency reasons. On the other hand, if you're going to keep your model in-house, then maybe you can have it learn those characteristics and deal with that by filtering the output. The final point that I'll just skip to is I think, and the Europeans have already taken this step. I think if you're going to be relying on the fair use as your justification for copying millions and millions of copyrighted works, the least you can do is preserve good records. And then we need to think about what's a sort of responsible system for letting people query those records and understand whether or not their works might have been used in the training data. But yeah, that's probably enough talking from me. If you want to know more, you can look up some of my previous works, and other than that, I'd be happy to take questions.